Ms. Atterbury has some of the most legitimate reasons for missing said court dates that I've heard. There was
This case is wild. A guilty plea turns into one of the most shocking bond hearings you'll ever see. Jessica Atterbury stands charged with cocaine use, a misdemeanor that could mean jail time. But when her attorney explains why she missed court, the entire tone changes. Jessica isn't just another defendant. She's a survivor of both a stabbing and a shooting. 2 violent attacks. Same alleged perpetrator. Stick around, because the judge's reaction and the final bond ruling will surprise you. And tell me, if someone's fighting for their life, should that excuse missing court? Comment below.
Court does call the case of the people versus Jessica Atterbury.
Good morning, Judge. It's good to see you. Christina Costantino on behalf of Jessica Atterbury. Ms. Atterbury, can you please state your name for the court? Jessica Atterbury.
Court does have before the plea form that indicates the defendant will be pleading guilty to the charge of use of that cocaine, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
That's correct, Your Honor. That's correct, Judge.
All right, may I have her sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
State your name.
Jessica Atterbury.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of cocaine. That is misdemeanor, punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
Sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand that you'll be giving up your right to appeal of rights.
Yes.
Are you on probation or parole?
I'm not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes.
On the date of September 18, 2023, at the location of Plymouth Road, City of Ann Arbor, Washtenaw County, State of Michigan, were you in possession of cocaine?
Yes.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
Ma'am, if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, the court would not be bound by any evaluation or recommendation regarding sentencing, and you could not withdraw your plea. You understand that?
I do.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
Here's where the courtroom shifts. The defense reveals Jessica's story: 6 stab wounds, a gunshot injury, multiple surgeries, and suddenly her missed appearances start to make sense. Legally, her attorney's argument is solid. She wasn't hiding, she was hospitalized. But emotionally, it's heartbreaking. What would you do if trauma clashed with the law like this? Should courts lean toward compassion or stay strictly by the book?
And have I complied with the court?
The defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and review. 15th District Court probation. Sentencing in this matter will be
September 12th at 8:30 a.m.
September 12, 2025, 8:30.
Thank you, Judge.
Right.
I believe her bond is currently listed as denied.
Yes.
So I would like to address bond if the court would allow me to. Just briefly. Judge, I understand the court there were some missed court dates here, but I think actually Ms. Atterbury has some of the most legitimate reasons for missing said court dates that I've heard. There was I don't know if ever, but pretty
Okay.
good, pretty
Okay,
epic,
go ahead.
Judge. I mean, really up there. She was unfortunately the victim of a severe stabbing. She has 6 stab wounds from an incident that occurred in Roseville. That incident occurred at the end of February. She was hospitalized after that into the beginning of March. She had several blood transfusions and was released from the hospital. After that, she was unfortunately the victim of a shooting in her leg. She has a leg wound and was hospitalized for 2 weeks as a result of that injury. That occurred during her last court date, which was in March. She was hospitalized for 2 weeks until the end of April because of that, the shooting. And Judge, I know that sounds like maybe hard to believe, but it's not.
So, go ahead.
It's not, Judge. There is actually a separate case out of Macomb County where Miss Atterbury is the victim of that case. An individual has been charged with attempted murder as a result of both the shooting and the stabbing, which were 2 separate incidents.
There were 2 separate incidents, same alleged perpetrator?
Same alleged perpetrator, yes. And different incident dates that occurred during the course of her last court date, which was in March. She obviously has quite a bit of medical conditions as a result of that. She's still in need of wound treatment for her stab wound, or for both, I'm sorry, the injury to her leg from the gunshot. She is still requiring medical treatment for. She's receiving some treatment at the jail, but of course it's not quite the same. She does also need to see a surgeon, and her injury from the gunshot wound will require 4 more surgeries. Given that, we are asking if the court would consider either a personal or a low bond with perhaps a GPS tether that would alleviate concerns as it relates to risk to the public or flight.
Response.
You're the concern of the people, that all sounds absolutely terrible, but it does look like the defendant was originally arraigned on March the 1st, a Saturday, and released to go to community corrections the following Monday. Didn't ever show up, and then we didn't see her for all those other reasons. I'm just concerned if there will be compliance if we are released. If she is released, I would request that the court reinstate the same conditions. So for weekend testing at community corrections.
The prosecutor doesn't deny her pain, but pushes back hard. Their point? Everyone has reasons, but the court still needs compliance. And they're right. Trauma explains behavior, not excuses it. Judges have to balance sympathy with accountability. Would you trust her to follow bond terms after all that chaos?
And Judge, we've discussed that. Miss Atterbury recognizes she did not report to community corrections. She admits that things have changed, obviously, in her life. She has no issue complying with any sort of testing. I will indicate to the court that she informs me she has not drank alcohol since 2013. So I don't know that SoberLink would necessarily be of much value, but of course, she will comply with any and all testing, including any sort of drug testing. The only other thing I'd point out to the court is obviously now she has pled to a misdemeanor. So we'd ask the court to take that into
You just want to keep talking?
No, Judge, I think I'm done.
Okay, you're done? Are you?
I think
I mean, I
so.
don't want to interrupt you,
No,
but,
I think I'm good now.
okay. I will reinstate her previous conditions. I'm not sure that a sober link is necessary in this matter, but the drug testing component, I'll reinstate
Absolutely.
that. And I'll reinstate her previous bond at a $20,000 personal recognizance fund.
Thank you, Your Honor.
Thank you, Judge.
In the end, the judge walks the middle line, reinstating her $20,000 personal bond with drug testing but no alcohol monitor. It's fair but cautious. This case shows how messy justice can get when trauma meets the courtroom. Was this compassion or leniency? Drop your thoughts below. And if you found this case as intense as we did, like, share, and subscribe for more real courtroom breakdowns every week.
Court calls case People versus Brandon Fleming.
Sorry to interrupt. Jake Hill on behalf of Mr. Fleming, who's coming
And then we have the people, Your Honor.
in. Judge, can we set this matter for exam? What I'm going to ask Your Honor is, I noticed you've been setting them for the 9th. I have a probate trial that day. Can we do it the
Trying
following?
to pick your date.
No, I'm not trying to pick the date. We could make it, no, I'm not. I'm just asking if we can go the following week, if possible.
Would there be any objection from the people? Discovery is complete, Mr. Kilowold.
Yes, Your Honor.
discovery being complete. Is he held on anything else?
No, Judge, he has no other charges. I was gonna make,
Well, then I've got a problem. I'll be honest with you, I got a problem then putting it out 1 week. We've got a ton of people in custody. I have 65 today. And
if you want to make it next week, that's fine with me.
no, it would be the 9th. I mean, my problem is, Mr. Killawall.
I'm sorry.
Putting it out an additional week, he's gonna remain in custody, and it may be that he doesn't have to remain in custody.
Can I address bond first? Just very briefly?
And then I can set it for the 9th and tell you to work it out. But you can go ahead and address bond.
Judge, he's 32 years old now. The only prior criminal history he had when he was 19, he had a felony. He's working. He promises to stay away from the victim. And again, I'm not trying to denigrate the victim, but she also has been charged with assaulting him. It's a toxic relationship. He understands that now. He will stay away from her. If the court would grant a bond, even if it's tethered bond, he will appear for court so we can address this issue.
This case is intense. Brandon Fleming faces domestic assault charges, and the courtroom tension is instant. His lawyer paints him as calm, working, cooperative. But when the prosecutor speaks, everything flips. She says the victim was pregnant, 7 weeks, and claims Fleming choked her until she couldn't breathe, then pretended to be her on the 911 call. That's chilling. Add prior domestic and sexual assault convictions, and the request for a $50,000 bond suddenly feels justified. Would you trust this man out on bond, or keep him locked in for safety?
Your Honor, I would object to any modification of bond. In this case, we originally requested $50,000 cash surety, so I think $20,000 cash surety is a gift, honestly, based on these facts. The victim and defendant were dating. She was 7 weeks pregnant with their child. A friend reported hearing ongoing abuse by the defendant against the victim that included loud noises, screaming, banging. She overheard the defendant telling the victim that he was going to kill her and the baby. She called the police. And during this incident, he was accusing her of cheating on him. He then pushes her to the ground. She gets up, tries to call her father, and then grabs her, barely her from behind, pushes her onto the bed, and puts her arms down. He then uses his body weight to push her face into the bed, impeding her breathing, all while she's telling him she cannot breathe. I have concerns given that in his criminal history, he has a conviction from 2015 for 2 domestic violence charges, as well as assault with intent to commit sexual penetration. And after this incident occurs, he then calls 911 pretending to be the victim, saying that she's suicidal, that she has a knife, when it really was not her calling to try and discredit her and get ahead of her calling police about this incident. So I have concerns on that as well. And based on all that, Your Honor, I would ask the bond remain as set.
I have nothing further, Judge.
Well, I'll set it for the 16th. I'm not really happy about it. I mean, I think counsel has to make their.
Judge, I could be here on the afternoon on the 9th. If we could set it for a later time, I'll go with the 9th.
Well, I'll set it at 9. You'll have to, whose case? Is it mine? I'll just take it. And you have to let my staff know on that date that you're going to be late. And then we'll do that. But I am loath to have him sit in jail for another week.
That's fine, Judge. I appreciate your consideration. Thank you.
The judge keeps it careful, bond stays high, hearing moves forward. It's not about guilt yet, it's about risk. When violence and pregnancy mix, the system walks a fine line between fairness and protection. So what do you think? Was the judge right to play it safe? Drop your thoughts below, and hit subscribe for more real courtroom drama every week.